Well, good morning. Welcome to the Law Show. Bob Kerrigan with you this morning, and we will address some legal issues this morning um, based on some of our viewers who have called us or texted us or emailed us with things that they're interested in. Our firm specializes in a relatively limited area of litigation, any cases that involve litigation, but primarily in accident and death claims, and we've done that for a long time. The lawyers are all board certified at Kerrigan, Estes, Rankin, McLeod, and Thompson. We don't have associates that are learning, and we don't rotate lawyers in and rotate lawyers out, so you don't know which lawyer's representing you. And we don't have our support people practice law. Sometimes people have complained to us, well, I never even get to speak to the lawyer. All I end up talking to is the paralegal or support person, and the lawyer's busy. And if lawyers are too busy to talk to the clients, they're probably too busy to handle your case. And so you should be able to speak with a lawyer, and the lawyer should address the questions that you have. The staff that work with us, our staff, are highly trained and qualified and can answer many questions, but where the client prefers to speak directly to the lawyer, the client's interest or desire to speak to the lawyer should be honored. And we're happy to do that for our clients. Today, I'm going to talk about reverse mortgages. In the last few sessions here of the Law Show, we have talked about Medicare and, in our view, the disastrous state of Medicare in terms of the complexity presented to the average citizen. It's almost impossible to decipher through these options that are out there. And the truth is, it's just loaded with middlemen and middle players and promoters and hustlers, and everybody's making money or trying to make money off of Medicare. And we're not getting it to the hospitals and doctors that need it and deserve it, and it's not being paid timely. It's being held up not by Medicare, but by all of these intervening entities that substitute for Medicare, like the healthcare advantage plans. And it's just a tragic state. And as I've mentioned in the past, we don't really have somebody speaking for the consumer. So we're going to continue to talk about it, continue to make people aware of what is going on with Medicare, so that when this renewal period comes up next October, people will be better prepared to deal with it. Bottom line is, if you don't understand it, don't sign it. That's what I always say. If it's not clear to you, don't agree to do it. And if something seems free, it rarely is. It almost always costs you more in the end than the original plan, which is Medicare, which is an excellent hospitalization plan that's designed for people who have worked all their lives and are now in their senior years, in advanced years, and want good quality medical care that they have paid for years and years and years during their working life. And it's just a shame that it's been so exploited and used. There's a very exhaustive analysis by the Kaiser Foundation on these various components of Medicare. They're not nearly as critical about Medicare as I am, but it's useful. If you Google it and try to get to the bottom of all of the nuances of it, it's just not very easy to do. On reverse mortgages, and before I get to reverse mortgages, thank you for texting us with your questions about other areas of the law. Sometimes we'll look at an issue that is of community interest. For example, we had some calls relative to a driving range. I won't tell you exactly where it is, but the driving range is set up in a way that flying golf balls literally crash into people's windshields and their windows, and it presents a hazard, a serious health hazard to the people around. I went out and looked at this facility and saw golf balls all over the place around these people's homes. And so the argument is, well, you decided to buy a home near a driving range, tough luck. There is some truth to that, but if the hazard is a public nuisance that creates a health and danger exposure to anybody who happens to be in this neighborhood, you could be walking up to this house or getting out of your car, and the windshield can get smashed. So we're going to try to do something about that, just as a matter of public service for the people that are involved. questions from people who've been in accidents, and the lawyers say we can't do anything about it. There's no insurance. We can't find the insurance. We look at it because sometimes we can find it. We have been very successful in discovering the availability of insurance, and we are especially skilled in the subject of insurer bad faith. Bad faith is the failure of an insurance company to pay its policy limits when it could have and should have paid them to protect its insured. We've had many, many cases involving insurer bad faith. At one time, I had the highest verdict in the state for insurer bad faith. So we look at that and we test the various components of what it takes to make a case, whether it's someone that is driving on an errand for someone else, or someone who's driving for an employer, or where they've concealed the actual owner. We look every place we can look to see if there's insurance in cases where lawyers have said they just were unable to help a client. We had one man text me last week and laid out just a tragic state of injuries that he had, and that he pretty much struck out with the lawyer that he had. So we're going to look at that for him, see if we can't figure out some way to recover. Not an excellent chance to do it, but we're going to take a shot at it anyway and see what we can. Cases like this, as I've said in the past, are handled on a contingency fee basis. That is no charge and no fee unless a recovery is made. I would be leery about this in terms of lawyers advertising. It's easy to advertise, but the qualifications of the lawyer should be examined carefully before you retain somebody, especially if it's a lifelong situation where you're going to have a disability or a serious injury that you're dealing with for the rest of your life or the rest of a loved one's life. Take the time to investigate the lawyers and find out if the lawyers are truly competent and qualified to undertake a serious case. It takes financial depth to do it, and it takes experience. And we have both, and we're happy to answer any question you have about our qualifications and experience. Not to say other lawyers are not equally qualified. There's many fine lawyers that are practicing law across North Florida. But you have to be careful that the lawyer you actually hire, not a firm that sends you to somebody else, or to a lower ranking lawyer in the firm, or a new lawyer or something, but the lawyer that you hire, we recommend be board certified in this field and this level of expertise that's required for board certification in Florida. All of the partners at our firm are board certified. All right, so what about reverse mortgages? We've talked about the exploitation of the poor, of the working poor, and exploitation of the elderly, which we've seen in Medicare and other areas, the scams and schemes that are all designed to take money from people without just cause. And it's prolific. It's every place, every phone call. I'm so absolutely tired of the robocalls I get from, there's one local weekly paper that does robocalls. It seems that we get them at our house. I don't know how many. I've had 6 or 7. You try not to answer them, but some of these calls are from organizations that claim that they're helping others. Hi, Jim. First of all, they hardly ever have the right names, but hi, Jim, this is Frank. And they set up the call like you're communicating with them and like you're talking to them, but you're not. Okay, it's a recording. And they say, well, we're raising money for our first offenders, and we're raising money for our firemen, and we're raising money for this, and we're raising money for wounded soldiers, and on and on and on and on. And when you dig down, you find out that the vast majority of the money goes to the fundraisers. If not all of it, the vast majority of it goes to the fundraisers. But the political robocalls are just gone completely wacko. We get them all the time. Our phones are just the funneling of sources, of outside sources interfering with our home lives, okay? I mean, you should turn the phone off. It's so bad. Oh, we want to find out what you think about the mayor. We want to find out what you think about the stoplight or whatever. And then they sell that information, or they use it in their newspapers or whatever to promote themselves and to make money. Everybody's trying to make money at the expense of others, okay? Not everybody. A lot of people are trying to make money at the expense of others. But I want to talk about reverse mortgages because just in a nutshell, they're terrible. they're just subject to excessive fees. So I'm going to go over some of the highlights of it right now. But you start with the reverse mortgage. The idea is you have equity in your home. That is, that you have value in your home over the debt. In many cases, people have worked all their lives and they don't owe any money on their home. So you have this money, this house sitting here, you have value in the house. Your income is not what you need to get by to do the things you need to do. It could be additional medical expenses, helping your family, whatever it might be. And so the idea that you get some money out of your house without selling it sounds very attractive. And it is attractive to this extent. If you don't have any relatives or heirs that you care about leaving your home to, then it's conceivable that you could just drain out with a reverse mortgage. And the way that works is they pay you each month. Okay, it's possible that it might work for you, but 90% or more of the people, it doesn't work for them at all. It's just a bad deal. Okay, but what they prey on is that you love your home, you don't want to leave it, and you think this is a good solution to downsizing, is you're drawing money out and you're drawing some equity out, and it sounds good. And it might be okay for you. I don't recommend it for the following reasons. There are super high fees to set them up to $15,000 just to set the thing up. You continue to have to pay property taxes and homeowners insurance. In fact, you have to maintain the insurance policy they tell you have to maintain, because now it's going to protect them, because ultimately they're going to own your home, most likely, because you're not going to pay off of it. You have to continue to pay mortgage insurance. I think it's 1.25% to get federally insured mortgage insurance. The loan amounts are capped. That's not usually a problem for people because the cap amount, I think, is like $625,000, but it's still capped. Interest continues to accrue on this. In other words, every penny you take out, you're paying interest on this. All right. So this is, you're paying interest on the amount that you're borrowing. Sorry. So all amounts that you borrow, you have to pay interest on. There's a real lack of choices in the marketplace for the major reverse mortgages over $625,000. I think there's only one company in Tulsa that even does it. So you have no competition there. But in the ones that you do have competition for, you have stringent repayment rules. I mean, just the strictest possible rules for repayment. And by the time you add up all the fees, we did an analysis of this. I'm trying to find out where I put it, but we did an analysis of this that showed the amount of fees that were charged. There's an excellent article that I found on Bank Tracker. It's 10 reasons to avoid reverse mortgage loans. There was an example of, and I can't find it right now, there was an example of the kinds of fees that were charged and how they mount up on these reverse mortgages. And it was prohibitive, just prohibitive. Best plan is either sell your home and accept the fact that you're downsizing and get out of the house, get the equity that you've built up in the house, or go to a bank and arrange some kind of bank financing as a second mortgage. That's a much better option to you. Avoid reverse mortgages if at all possible. Don't get involved in them. Maybe in another segment, we'll talk about all of the costs and fees that are associated with them. There's a bunch of them. We'll be back after this message. Bob Kerrigan for Kerrigan, Estes, Rankin, McLeod, and Thompson. What is medical malpractice? In many ways, it's similar to an auto accident. If a driver of a car is careless and causes an accident and injures someone, the driver is responsible for those injuries. If a doctor or employees of a hospital violate the rules of medicine, they're responsible for the injuries they cause. These rules of medicine make up the standard of care that doctors and hospitals are required to follow. Medical malpractice cases are expensive to bring and can be very difficult. We're required to retain qualified medical experts to assist the jury in understanding why what was done violated this standard of care. At Kerrigan, Estes, Rankin, McLeod, and Thompson, we accept meritorious medical malpractice cases where substantial injuries or a death have been caused by a doctor or a hospital failing to abide by the rules of medicine. Please see our reviews on our website at kerrigan.com. Welcome back to the Law Show. Bob Kerrigan with you, picking up on where we were a few minutes ago. talking about reverse mortgages. Here's the problem. People do not want to accept the fact that it's time to figure out what they're going to do with the rest of their lives and where they're going to live. Particularly difficult for people to downsize who love their home and been in their home. And they want to figure out a way to stay. But if you care about the great value that you've had in your home going to your heirs, your children or grandchildren, you should think very carefully about either selling your home and downsizing or going to a bank and effecting a second mortgage if you're able to repay it. Where the reverse mortgage people get you is that most banks will want repayment of the money that is loaned to you. And the reverse mortgage people say, well, you don't have to pay it because we're going to pay you each month. Okay, so it sounds appealing. The problem is in the costs and fees that are associated with, they're prohibitive. Okay, prohibitive. If you can avoid reverse mortgages, avoid them. We had a family member that got involved in one that none of us knew about, but she wanted to be independent on her own and make the decision herself without consulting anybody, and she got talked into a reverse mortgage. Now, there are people who tell you how great they are. All I'm saying is it's extremely expensive. I mean, almost cost prohibitive in my opinion, but at the least extremely expensive to engage in a reverse mortgage plan. Now, if you all will recall, for those of you who've watched the Law Show, thank you for doing so. I won't suggest that people watch every week. I mean, it's a little much to watch at all, probably. But anyway, we're glad that you're watching today, if you are. But in the past, I've talked about payday loans and title loans and how prohibitive their interest rates are. You don't have the cash, and so the working poor are faced with very few options in terms of money that they can borrow. The borrowing rates are high, and with title loans and with payday loans, they're just through the roof. Okay, payday loans up to 300% interest, and title loans 24%, 18%. 30%, depends on the loans, but they're all extremely high interest rates. Now, there was some serious inroads to protect the public that were in existence, but sadly, they have been lost since 2020 based upon people who've been appointed to the Consumer Product Safety, rather the Consumer Community organization that is involved with the control of or regulations over these title insurance companies, or title companies, and payday loan companies. All right, so the National Association for Latino Community Asset Builders, represented by this outfit, Public Citizens, I've told you about that before, and the Center for Responsible Lending sued the U.S. Consumer Financial Protection Bureau. That's the agency I was inadequately representing previously here. The Consumer Financial Protection Bureau, okay, in October in the U.S. District Court for the District of Columbia, seeking to overturn a regulation issued in July of this year concerning short-term payday and auto title lending. Okay, the regulation repeals consumer protection measures that the agency adopted in 2017 to protect vulnerable consumers from an unfair and abusive practice. The lawsuit explains that the 2020 rule is unlawful under the Administrative Procedure Act and violates the Dodd-Frank Wall Street Reform and Consumer Protection Act. Payday and auto title loans are short-term loans that the lenders typically offer without assessing borrowers' ability to repay. Annual interest rates can be up to 300%, as I meant, or higher. Lenders' failure to underwrite traps many borrowers in expensive cycles of unaffordable debt. What this means is you're trapped where your asset that you've placed or signed the title over has put you in a position where you can't repay it. You've gotten the money back, and they're going to end up getting your car, okay? Which further escalates the poor into poverty because they don't have transportation then to get to work. And the cycle is just not good for a society. A civilized society shouldn't condone this stuff. And yet it's pervasive because there are a handful of people making a lot of money with it. And that's why they have enough clout and enough political influence to have affected this revoking of this rule that was in existence to protect the consumers. In 2017, after years of research and public engagement, the CFPB issued a rule to address the substantial harm that consumers suffer when payday and title lenders make loans without reasonably determining that the borrowers can repay. In other words, they don't care if they can repay. In fact, they probably assume they can't repay, but they're going to get their car. They give them a little money, they're going to get their car. In its 2017 rule, the CFPB concluded that the practice is unfair and abusive and adopted measures to protect consumers from the harmful practice. Good. It was good. It was positive. There was some protection out there, okay? However, in July 2020, the CFPB issued a new rule that prevents those consumer protections from taking effect. Here's a quote from a person that was involved in the litigation. Payday and auto title lenders are the proverbial bottom feeders of the financial services marketplace, said Noel Andres, FOIO, executive director for this organization that brought the lawsuit. They make more money when their customers fail because they seek to catch the poor people in a trap of revolving debt and then use penalties and fees to fleece them of what money they earn. Why the CFPB would ignore its own research and overturn its own rules to make these abusive practices easier makes no sense. Indeed, it doesn't. And there's going to be a move now to change that, change the administration of the organization, and to gut the lobbyist for these title loan companies and payday loan people, and to gut the lobbyist effort to abandon these rules and regulations that were designed to protect the consumers. It just seems like it's every place. Not to be too pessimistic about it, but the traditional sources of financing for people, established banks and credit unions, operate at the highest level generally of integrity and fairness. And all of these others that are out in the marketplace offering money, offering discounts, offering benefits or whatever to people, you just have to look at it with great suspect. Sad as that is, and the goal of the Law Show, among our other goals, is to acquaint you with things that are going on that are abusive of people in terms of their vulnerability, particularly the elderly and the working poor, and to bring that to the public's attention and have a discussion about it. We had a number of calls and emails in the last couple of weeks. We're getting more and more text messages. By the way, we invite your text message right now, 850-444-4444. We try to answer these texts on the air when you call. Not on the air, but we try to answer them when you call during the time that we're on the air. And if not, we get back to you shortly after that, sometime Sunday or Monday, to respond to your questions. A lot of the questions are dealing with issues in areas of the law that we don't practice, so we will refer people to areas where they can find a lawyer that has that kind of expertise that we might not have. We had an interesting call in the area, as I mentioned earlier, about the driving range, but we also had a call about a practice of lawyers contacting people after an accident. And it's an awful practice. It's prohibited. You can't do it by law for 30 days. But we see it happening more and more. There's so many lawyers that are advertising for automobile accident cases and other injury cases that we've had people openly solicited. They've been solicited in hospitals, and I think I mentioned this maybe on this version of the law show. We've had the law show in existence for probably 25 years, but in this current edition, I don't think I ever mentioned it, but we had a case in Louisiana where a person was purporting to be a Catholic priest and was passing out Bibles, but was also passing out cards for lawyers. Our client was badly burned on an oil rig accident and was solicited in the hospital. Solicitation in a hospital is obviously unethical and in some cases illegal, or any kind of solicitation like that. If you're contacted by a lawyer who tells you he's going to represent you and handle your case, and I mentioned this, I think, in this version of the law show, where a lawyer in Georgia sent a limousine to a client down in central Georgia, someplace, to drive her to Atlanta when her husband was killed, like she would be impressed, like she would be so stupid as to think that a ride in a limousine meant that the lawyer was competent and qualified. This lawyer's a hustler and promoter and was not the kind of lawyer you'd want to be in the courtroom with, but people don't know that, don't know what effect the lawyer is going to have in the courtroom or with judges, and so they end up sometimes responding to these kinds of solicitation. It's not a good sign. It's not a sign that the lawyer's competent or qualified at all. You should ask hard questions of anybody you hire to represent you, especially where you're going to have a lifelong injury or a lifelong disability of some kind. You should make every effort to try to ascertain that the lawyer's competent and qualified. The Florida Supreme Court has a listing of the kinds of questions you should ask, very specific questions. You can get that off our website, or you can contact the law firm and we'll get it to you and it assists you in answering and asking the right questions of a lawyer that you are going to consider hiring. Our website is Kerrigan.com, Kerrigan.com. We will cover questions that we have received. Interesting question about an inheritance that we received this last week. And we help the person by going to the law of intestate succession, which tells you how property is transferred if there's no will. We were happy to do that and assist the folks in trying to figure that out, because they were unsure of what was going to happen because this person died without a will. We'll be back after this short announcement. Kerrigan, Estes, Rankin, McLeod, and Thompson is the sponsor of the Law Show, and opinions expressed here are my own and those of our law firm many times, but they're not of this television station or anybody that appears on the program. I'm Bob Kerrigan. Have you seen the young lawyer advertising standing on top of a truck? I wonder who he would hire if he fell off the truck. Maybe the lawyer who has hundreds of billboards up and down the interstate. If it happened in Florida, though, it couldn't be him because he doesn't even have a Florida law license. He wouldn't hire the lawyer who barely has time to eat with his family because he just seems too busy. Maybe the lawyer who busts down his office wall, but that may not be a good place to be if another wall is crashed through. If he called us, we'd tell him it wasn't the brightest idea to climb up on top of the truck in the first place. With the highest ethical and legal ability rating from Martindale-Hubbell. We represent one client at a time, and we've represented thousands of clients over the years. Your case will be handled by a board-certified partner, board-certified in civil trial by the Florida Bar. Kerrigan, Estes, Rankin, McLeod, and Thompson at Kerrigan.com.
Welcome back to the Law Show. I'm Mike McLeod, and I'll be with you for the next couple of segments of the show this morning. The law firm, Kerrigan, Estes, Rankin, McLeod, and Thompson, sponsors the Law Show. We have offices across Northwest Florida. We limit our practice to helping people who've been seriously injured in accidents and representing the families who have lost loved ones in accidents through no fault of their own. We've been around for a long time, over 40 years. Bob Kerrigan and George Estes started the law firm back in the 1970s. Bill Rankin, myself, Randy Thompson joined the firm, and we've been together for a long time, just limiting what we do only to cases that involve serious injury. We've hosted the Law Show for almost all of those years, and we invite you to text us with your questions if you have them today. You can text us at 850-444-4444, all fours. We also like to advise you that's our main number. So if you want to call the law firm any day of the week, you can reach us at that number. Our website that has a lot of information about all of us and about the law firm is Kerrigan.com. It's on the screen there. And my email address is mike.mcleod@Kerrigan.com. You can email me a comment or question about the show this morning. So I first want to talk about a little bit about how to select a personal injury lawyer. And I think this applies to lawyers who do all sorts of work, but particularly accidental injury lawyers, because there's so much advertising in the market today from those types of lawyers. And that's the type of law we practice. So, you know, if you ride through town, if you ride through Northwest Florida, you're going to see predominantly billboards, that a lot of them from personal injury lawyers, accidental injury lawyers. If you flip on your television set, you're going to see advertising from a lot of personal injury lawyers. Personal injury lawyers market directly to people through those types of media. You know, years ago when the phone book was still kind of a big deal, the Yellow Pages was, I'll bet 25% of the Yellow Page ad were from personal injury attorneys. So the question is, are those the best ways for you or your family to pick a lawyer to represent you in a serious injury case? And we have billboards. We have a phone number that's an easy phone number to remember. We love our phone number. It's easy for folks to call us and remember. You just start punching forward till we answer the phone. But is that really the best way to pick a lawyer in a matter that's of really critical importance to you? And I suggest that it's not. So how do you, in a time when you really need help dealing with insurance companies and things that you're not familiar with, how do you level the playing field against insurance companies by picking the right lawyer? And I suggest that there are some objective things that you can look at and consider to make sure you pick the right lawyer. So by objective, I mean things that you can aren't subject to interpretation. Like you may see an ad where a lawyer says, well, I'm going to fight for you, or we'll holding up the scales of justice. Here's the scales of justice with me this morning. Well, but does that really tell you something about the lawyer's history in an objective sort of way? And I think it does not. So let's talk about some objective measures that will indicate to you this is a lawyer who can really help me. And the first thing is board certification. So in Florida, the Florida Bar allows lawyers to indicate to the public that they are board certified in certain areas only if those lawyers have met the criteria to present to the public that they're board certified lawyers. We are board certified civil trial lawyers at our firm. All of the practicing lawyers are board certified civil trial lawyers, which means they have met peer review. Other lawyers have recommended them for board certification. Also, judges who they have practiced in front of have recommended them for board certification. And then a lawyer has to take a very specific specialized test just in this field and pass it in order to uh, announce to the public that they're board certified. So that is an objective measure that the lawyer has taken, not just gone to law school, passed the bar exam, but also become board certified in a very, very detailed and somewhat strenuous process. Fewer than a few percentage points of lawyers in Florida are board certified civil trial lawyers. So board certification is an objective measure. Also, how long has the lawyer or law firm practiced in this area? That's a number that's not subject to interpretation. Our firm's been here for 40 years. Why is that helpful? Because lawyers who live here and work here and practice here know the legal community, know the atmosphere in the courthouse, know the atmosphere for jury verdicts, know the judiciary here, and that is a tremendous benefit for a person who's going to have somebody represent them at the courthouse and with other lawyers on the other side of the case. I think it's very helpful for my clients to know that if I tell a defense lawyer X, Y, or Z, by my reputation, the other lawyer's going to know that that's accurate and true. And I think that's a real benefit for our clients when they consider hiring our firm. And that's an objective measure. The other thing I think is, what are the lawyers' verdicts and settlements historically? So years ago, the Florida bar wouldn't allow lawyers to publicize through advertising what their verdicts and settlements were. But those days have changed and those restrictions have gone away. And so now a person who is thinking about hiring a personal injury lawyer can ask, well, what are your verdicts and settlements? And the easiest way to find them in our case is to go to our website, Kerrigan.com, and there's very easy to find. You just click on verdicts and settlements, and there's a long list of verdicts and settlements that our firm has obtained over many years, and that's something that's not subject to opinion or interpretation. Those are facts. And so verdicts and settlements are available now. Client reviews. Now, in the social media age, lawyers can can ask clients to write a review. Clients can write reviews, positive and negative, on their own, and those are available. So, also on our website, again, it's Kerrigan.com. You can go to our what do our clients say about us, and we put them, they're all on there, and you can read what individual clients have said at the conclusion of their case about all the lawyers with the firm. So these are all objective things that you can test when you decide who's going to represent me in a case. I think it's kind of interesting when you go to the grocery store, and you'll see people pick up a product, like it could be a bottle of ketchup, and reading the label to see, well, what's in this product, what's in this, and kind of scrutinizing what kind of salad dressing am I going to get, or what are the fat calories in this. And people scrutinize these products that you pick anywhere. It's so readily available today, but are somewhat more careless perhaps about picking an attorney to represent them in a matter that is of real great importance, that affects their livelihood, their medical expenses, their medical bills, recovering from an accident that wasn't their fault. So I think these are all things that a person can look at and scrutinize. So the other thing is, and this is the last thing I think, I don't think it's a mistake to meet with several lawyers. If you have a really significant case where you have serious injuries, then it's certainly, I think, wise to meet with more than one lawyer and compare, because I think over a meeting, even a 30-minute meeting, face to face, it's harder now during the COVID age, but people can mask up and we can do Zoom meetings. And I just think you can get a feel for connection to a lawyer through a face-to-face meeting. And I think it's wise in many significant cases to meet with more than one lawyer. So it's just not something that you willy-nilly drive past a billboard and just pick somebody out and drive on. The other thing is law firms have more than one lawyer in them. And so we think it's very important for you to know what lawyer in the firm is going to represent me. Am I calling a law firm that has a big number of lawyers and I'm going to get whoever they pick for me? That's not necessarily the way I would want to be represented in a matter that I'm counting on this one person to do a good job for me. All right, so the next part of the show and into the next segment, we're going to get back to our mailbag and try and answer some questions from viewers over the next few minutes. And the first one comes from someone who says, what happens if both parties to an accident have the same insurance company? So it's really pretty common. And a lot of the mainstream common insurance companies, Allstate, State Farm, Progressive, Geico, we see those names a lot. And it's really very common for a car wreck between two vehicles, two drivers, for those two people to have the same insurance company. And it does seem like, I think, well, you know, whose side is my insurance company on when they're on both sides of the case? So in the typical accident, if you're injured in the accident, you would look to your own insurance company for payment of your medical bills and lost wages, even if the other guy's at fault, under your personal injury protection coverage. And your insurance company will assign a claims handler, an adjuster, to handle your case with your own insurance company. And so that adjuster will deal with your PIP payments for your medical bills and lost wages. And if you have coverage called uninsured motorist coverage, you may have an additional claim against your own policy, and you may deal with that same adjuster for your company or a different insurance adjuster for your own company. Then on the other side of the case, the car that hits you, even though it's the same insurance company, will assign a separate and distinct insurance claims handler for your claim against the other driver. And those two insurance adjusters with the same company are not to communicate with each other. The regulations require that they not communicate unless you give them permission to do that. So there should be a real line of communicating between those two adjusters. It does happen really sort of often. I've got some more questions to get to in the next segment. We're going to take a quick break though first. Again, the Law Show is brought to you by the law firm Kerrigan, Estes, Rankin, McLeod, and Thompson. We handle accidental injury and wrongful death cases across Northwest Florida. We're proud to host the Law Show every Sunday morning at this time. And I'll be back again with more of your questions in just a minute. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. Welcome back to the Law Show on this Sunday morning. We're going to go back to our mailbag, question bag, and answer some questions from viewers in this final segment of the show. Again, this is the Law Show brought to you by the law firm Kerrigan, Estes, Rankin, McLeod, and Thompson. Our firm specializes and has for many, many years in representing people who are seriously injured in accidents. We represent families who have lost loved ones in accidents that were not their fault. We've done it for over 40 years. And we've hosted the Law Show over many, many years, and appreciate folks watching, and hope this is an opportunity where we can provide helpful information to the community. Our website is Kerrigan.com. You can find a lot of information about the law firm, the history of the law firm, and individual information about each of the partners in the law firm. All of the lawyers with Kerrigan, Estes, Rankin, McLeod, and Thompson are partners in the law firm. All have a tremendous amount of experience, years of experience, representing people in personal injury cases, trying cases, obtaining verdicts and settlements to help people who are injured, who have economic losses, medical expense losses, and accidents that were not their fault. And we've limited our law practice just to those cases. And lawyers do a lot of other great things for people, estate planning, family law, divorces, criminal defense work, all sorts of things. But we have, almost from the inception of our firm, decided years and years ago that we just wanted to do this particular work, and we wanted to be specialists. And all of the lawyers who practice and handle cases here at the law firm are board certified civil trial lawyers. And a very small percent of the Florida lawyers are board certified at all, and certainly in this area of law. My name is Mike McLeod. My email address is on the screen now. It's mike.mcleod@kerrigan.com. You can send me an email, a question to me at that address. We'll answer it on the TV show, or I'll reply to your email. Again, it's mike.mcleod@kerrigan.com, or you can text us at our main number, 850-444-4444. That number is answered also if you call that number throughout the week, and actually 24 hours a day, 7 days a week, we can be reached at that number. So let's answer a few more questions that have come in over the last week or two. The first question is, how much does it cost to hire a lawyer in a personal injury case in Florida? So, and we've talked about this before, lawyers who do this sort of work and who handle these types of cases charge what is called a contingency fee. And the fee is contingent upon a successful outcome. So all those other types of things that lawyers do, criminal defense work, divorces, adoptions, estate planning, business issues, lawyers typically charge either a fixed fee ahead of time or an hourly fee, depending on how much time is involved in the matter. In personal injury cases, the contingency fee allows someone who may have modest means or who does not want to pay a lawyer up front, whether the case is successful or not, to hire the best lawyers they can hire. And the fee is typically a third of the recovery, dependent, again, on a successful outcome in the case. So if a person comes into our office who's been seriously injured in an accident, we will put the full force of our firm, and we have very talented staff who most of them have done this work and who have worked for us for a long period of time. We will put that group of talented people and lawyers forward to assist you to make sure you are treated fairly as a result of an injury resulting from an accident that was not your fault. And the fee is not paid up front. The fee is not paid at all unless there is a successful outcome. And so this allows the client to hire the best lawyers they can hire and not to pay unless there is a successful outcome in the case. And then again, also, there are certain expenses that go along with pursuing a serious injury case. And those expenses can typically be the cost of acquiring your medical records. Physicians and hospitals charge for the copying of records when the client needs them or when the lawyer representing a client needs them. So we pay all of those charges as the case goes along. Sometimes when we get records for the at-fault driver, what kind of driving record does this person have? We do a lot of research into, well, how is this person who caused this accident driven in the past? So we get their driving record. We get a lot of history and information on the person who caused the accident. That's available. Sometimes we hire experts who have specific training in certain aspects of how a case happened, not necessarily always an automobile accident, but other types of accidents. And then sometimes we will meet with a client's treating physician in order to have the doctor project how is this person going to do after the case is over. What's this injury? How is this injury going to affect them as they go forward in life? And so doctors charge for those conferences and for their time for providing this helpful information that helps us put forward our client's case. So the contingency fee is one that's not paid unless there's a successful outcome. The costs that we incur pursuing those cases, the things that those examples that I've just given, are not charged to the client at all unless there's a successful outcome. So what do lawyers like about the contingency fee? If a lawyer is talented and able to get a very positive outcome in the case, the lawyer is going to be compensated for the work that he or she does. And what do the clients like about the contingency fee? I can hire the best lawyers I can find, and I don't have to pay them anything unless they're successful in the case. And it opens the courthouse door and evens the odds against insurance companies. Typically, it's an insurance company who have plenty of lawyers, plenty of employees who are all experienced in handling these cases. So it evens the odds for people that will find it hard to risk funds up front to make sure they are fairly compensated in an accident. All right, so next question was, what if the driver who hit me was drinking? So let's talk a little bit about drunk driver accidents. If a driver in another vehicle runs a stop sign, runs a red light, the most common accident really is a rear end collision. It's just human nature. We get distracted by different things. Cell phones are, of course, a big problem. But drivers get distracted, so it's very common for a person to come to see us and have significant neck or back problems as a result of a real rear end collision. So if a drunk driver rear ends you, it doesn't mean that they're more responsible. If a car rear ends you, that driver is negligent in most cases and responsible for your damages. But if the driver rear ends you and is intoxicated, then the case sometimes takes on different qualities. One, insurance companies that insure drunk drivers are, in our experience, more alerted to the fact that this is a case where a jury may award more money because our insured was intoxicated than if the insured just looked down to try and pick up a pen that was dropped or something that was dropped, because the fault part of the case is more aggravated. And we know historically that juries in Northwest Florida, and I'm sure juries everywhere, tend to compensate people that are injured with the same injury in a more substantial way because the at-fault driver was so careless as to drive while drinking. And so we think that cases where the at-fault driver was intoxicated result in bigger damages, even though the damages are the same as mom or pop who causes an accident inadvertently by running a red light. The second kind of difference that I would mention about drunk driver accidents is that in the typical case, a person injured in an accident has the right to be compensated for their compensatory damages in just the average case. And compensatory damages are lawful damages in Florida um, that are aimed to compensate the injured person and to compensate them for their lost wages, their medical expenses. These are bills that they have to make the injured person whole. And in Florida, in an automobile accident, if you have a permanent injury, you're entitled to be compensated for intangible type damages, for pain and suffering, loss of the ability to do the things that you could do and enjoy the things that you could do before the accident. But these are all damages to compensate the injured person. In Florida, if the at-fault driver is intoxicated to the extent that their normal faculties are impaired, the injured person also has a right to claim not just compensatory damages, but punitive damages. And punitive damages are not necessarily measured by, well, what happened to the injured party, but what is the bad conduct of the wrongdoing party? How bad was the person intoxicated? Is this the second or third DUI that the at-fault driver had? So in Florida, if the at-fault driver is intoxicated, then the injured person has the ability to recover not just compensatory damages, but punitive damages, damages that are measured to punish the at-fault wrongdoing driver. There are some procedural steps that have to be taken by your lawyer, if you've hired a lawyer, before you can trigger punitive damages. And just basically, those things are you have to get into the record the evidence that this person was intoxicated or this person's conduct was so reckless as to be tremendously reckless. And then you have to ask the court to allow you to amend your complaint to seek punitive damages. So there are some differences in cases that lawyers who do this can trigger punitive damages to punish the wrongdoer. We'll have some more questions answered next week. I've run out of time for this segment in the show. I'm Mike McLeod. This is The Law Show, brought to you by Kerrigan, Estes, Rankin, McLeod, and Thompson. And we'll be back again next week.